Welcome everyone, this is Tim Pullman and you're listening to the SEP Couch. This podcast is all about standard essential patents. We talk about patent strategies, FRAND licensing, patent pooling, and patent litigation. So let's dive into today's episode. Hello and welcome everyone. I have a very special guest here today on my virtual SEP Couch. We have here today with us Joe Casino. He is the IP chair at Wiggin and Dana, but also the managing trustee at Sun Patent Trust. And I'm super happy to talk to him today about SEP licensing. Hi, Joe.
Hi, Tim. So I'm glad to be here.
I am super glad having you. I know you have been in the industry for quite some time. You are a real licensing executive expert, and I am really looking forward to hear more about it. And as always in the podcast, however, I want to learn about the person and how you got into everything, who first bothered you with a standard essential patent, and when did you get first excited? So it would be great if you could walk us through your careers, your early steps, and where you ended up today.
You know, I have an interesting path to getting here because I wasn't thinking about becoming a lawyer. I wasn't thinking about getting involved in patents. I went to college at night and law school at night, and I was a teacher during that time. I graduated undergrad with a computer science degree, was looking to become a developer or programmer, but I graduated in 1991 in the midst of a recession. And I took the law school exam on a whim. I signed up a week before the exam was given, read the Barron's outline and happened to do well on the exam, decided to go to law school. I still wasn't focused on patent law. I didn't take any patent law courses. I took one light intellectual property course. I was focused on business law. I was taking corporations and bankruptcy, etc. And, I think that actually turned out to be a good background for what I do with licensing. And my first job out of law school, mainly because I had the computer science degree, was at a patent boutique. And they had a long-term relationship with Panasonic that went back to 1968. They had been patent counsel for Panasonic, and Panasonic asked them to put a liaison in their licensing office for a year. And that was me. I was a third-year associate. I went to Japan. It was my first time living outside the US. And I was in the licensing department and I got immersed in it. And what I find is, the fact that I was less focused on patent law, I think was helpful, because a lot of what you do in licensing is business oriented and requires skills beyond the technical skills. The technical is very important. And, I've been involved in many technical discussions, but the business discussions are very subtle. And I think having somewhat of a more diverse background than just being an engineer that always knew they want to be a patent lawyer was helpful for me.
Very interesting. Yeah, I can agree to that, right? It's a complex world, and in the end, it's all business. It's people business, right? And international people business, as you said. Give us some more background on all this. I think maybe not the audience will all realize that the Sun Patent Trust is actually a portfolio from Panasonic, and your current position, maybe also in your law firm, and what else you do, just to give us an understanding of your day-to-days and what a typical day for you looks like.
So I graduated law school in 1996, and I didn't become trustee until 2015. So before that, I was really a patent litigator that had always a lot more exposure to licensing than I think a typical patent litigator, because of my time in-house at Panasonic for 1 year. I continued after I went back to the US to be involved in cross-license negotiations and license negotiations. And that built the base for me to understand licensing more intimately. But at the same time, I was litigating big and small patent cases. So I knew really what happens after a negotiation, right? And how you could get embroiled in disputes that are very hard to end, very hard to pick a winner, very hard to predict a winner. So I had a quite interesting experience before I was trustee, and I still continue to litigate intellectual property cases as I work as managing trustee. So I get exposure to both sides of the equation, which I think drives me to work harder in the licensing, because I don't want it to result in litigation in most cases.
Right. I mean, that's also typically when it gets really expensive and as you said, like complicated. But you've been doing, patent licensing for years now, and not only SEPs, but of course, a good question I always have is what makes SEPs so special? And if you think about the past years of licensing and IP, do you see any trends? Has there been any changes in how SEPs are licensed, how deals are closed? Any learnings along your journey?
I'd start with the premise that maybe they're not all that different in licensing a SEP portfolio and a portfolio of, let's call them ordinary patents. I think it all starts with a good valuation. If your valuation is wrong, there's going to be a lot of friction and you're going to wind up in litigation. So you really have to give a lot of thought in any licensing program to the valuation aspect. And sometimes it's iterative. You might learn from licensees as you're starting your program. The other thing that I think is similar in both ordinary licensing and SEP licensing is you want to have consistency. At the end of the day, if you wind up in court, it's not going to paint a very good picture for a judge or a jury if your licenses are all over the place. They're not going to know what to do in terms of valuation and damages if you're not consistent. So I think, there it's the same. And the other similarities is I think you need strong patents on no matter what type of licensing you're doing. And, that's something you have to give a lot of thought to. Sometimes you have to really look at the flaws and try to find them before you start a licensing program. And in both ordinary licensing and SEP licensing, it's much easier to license when you have a portfolio. The value proposition is a lot easier. And if you don't have a portfolio, the temptation for the licensee to challenge your licensing proposition is much greater. So I think those are the similarities. Where it really departs in the ordinary licensing world in the SEP is in competitor cases. Once you get to a competitor case, if you're not dealing with SEPs and you're not obligated to license on FRAND terms, you're really looking at your commercial advantage, and that drives what you're doing in the licensing and potential litigation program a lot more. What is the commercial situation? Whereas in the SEP world, you typically are looking to license, and you're looking to license on reasonable terms. And I think that is a big difference. And then you also asked about what's changed. When I started, there were not and there were not that many standard essential patents. So in, the 25 years, there's been an explosion of the number of standards, the number of patents. There's a more scholarship on it. There's more decisions to look at from various courts, and there's more data. We had no data, when I started. There was MPEG-2, and you sort of knew who had patents, and there was a set price for the pool, and everyone joined, and it was pretty easy in a sense, although that was a really a very important marker in the history of SEPs to have that first standard that was where SEPs became important. But after that, licensors have invested much more money in their efforts and standards. Licensees are more wary of taking licenses because of the number of standards they have to deal with. And, in general, the amount of conflicts over SEPs has really increased dramatically. And maybe that's predictable when you have many more standards and many more people focused on SEPs. But it's a little unfortunate that we have so much conflict over this, and that, both, I think, licensors and licensees are struggling with what's the right balance.
And is that because we are entering new markets and new industries that, we're not yet accustomed to licensing SEPs? Is that also the complexity of more licensors? What do you think is the reason for that?
Well, I think it's both in the traditional markets, like cell phones, where you have many more patents because the cell phone is now a device that does things your TV used to do. And, it's got so many functions that, that's become a really hot area. And then, there are the new areas where SEPs are becoming important. We never thought about automotive companies, when I started. An automobile had very little, if any, electronics that required standardization. And I think automotive companies all had fairly equal portfolios, so they just stayed away from each other, and they didn't have a lot of litigation or licensing. Whereas now you have companies that are making technologies outside the automotive industry that are winding up in the car. The car has become similar to the phone, one place for everything, video, audio, navigation, connectivity, all sorts of things that were unpredicted. So I think you're right. We see changes by the expansion of the field, but even within the field, it's become tougher.
Yeah, no, I fully understand. And I think also it needs more solutions like pools and everything, which puts me to the next question. As a trustee of the Sun Patent Trust, can you elaborate a little bit about that portfolio? Because also that includes different standard essential technologies. And of course, probably, I'm sure you're licensing also into different industries with that portfolio. Can you give us a little bit of an understanding or elaborate on how was a Sun Patent Trust built? What's the business model? Why was it set up in the first place? What was the strategy behind it? And how do you approach licensing and commercialization? Bilateral, joining pools, also selling patents maybe. Can you give us some insights there?
Yeah, let me start with what Sun Patent Trust is and, why it was set up. Sun Patent Trust is a trust. And just as a family trust is set up, the reason is to separate assets and put it under management of someone else. So Panasonic was looking at many situations where it would like the patents to be independent of the businesses. And there you have several choices. You could sell your patents, but if you sell your patents, you have to worry about what the person you sold the patents to might do with them. Whereas a trustee relationship is somewhat different. You're giving up control of the monetization. You have to give that up in order to set up a trust. And then, but as trustee, I'm a lot more sensitive to the beneficiary's interest. So just as in a family trust, you might take into account, what the son and the daughter think of the way you're distributing the assets and how you're investing. I can, consider, well, I'm not going to go out there and sue Panasonic's main customer because that would hurt them more than it would help them. But that decision has to be in my power as trustee. And then if you look at what we do at Sun Pen Trust, we were given mostly standard essential patents by Panasonic. And that's because that comes from the R&D section there, which really has separate interests from the business. So by putting them in the trust, my goal is to monetize those patents. And I've used a variety of methods. I've used patent pools where I can. I don't have a staff or a big licensing team. So patent pools are a great solution for me. So where I can, I look at a good pool. And to me, a good pool is a pool where licensors and licensees accept it. So I'm always looking at how many licensors are joining the pool. Do you have licensees that are interested in taking a one-stop approach to the license? And in those circumstances, I use pools. With the cellular patents, other than Avanci, where I'm licensing them for the automotive industry, I'm doing mostly bilateral negotiations. And that's where a large part of my work focuses as managing trustee, trying to handle these very tough FRAND negotiations with many smartphone makers. And then, in certain circumstances, I have sold patents where it might be difficult for me to monetize. For example, if I have patents that are sort of all over the place, it's not reading them one clear standard. It would require potentially a lot of litigation to resolve the licensing. It's better suited for others to do that, and I have sold patents from time to time.
Interesting. So you basically use all, different ways of commercialization on the strategy. If you think about the different technologies, also your portfolio includes cellular, as you said, video, and other standardized technologies. Is there any differences of licensing, would you say, or is in principle licensing a cellular SEP very similar to a video coding SEP, or is it different industries, different practices?
I think different industries are different. The video coding industry has a long history of patent pools, and I started with the HEVC patents in the Velos pool, or the Velos platform. It wasn't necessarily a pool because it wasn't very large in the number of licensors. Eventually, I found that I wanted to gravitate towards who I thought would be the market leader for the HEVC, and we switched to Access Advance. And I think Access Advance has become a market leader with the HEVC, and I think they're well on their way for VVC as well. And I joined their VVC program. So I'm very happy with that. I do have some video coding patents outside the pool related to AV1 and VP9, and I haven't joined a pool for those on the device side, and I have entered into some bilateral discussions. I think the interesting thing in the video coding space is there's a lot of thought going into who's economically benefiting from the codecs. And traditionally, all the licensing has been on the device side. And I think there's growing interest by licensors and licensees to distribute that a little more evenly. For example, I have Verizon at home for my cable company, Fios. And if I order a movie in high definition, they'll charge me $1 more. So, I think that makes a clear economic case that the streaming company is actually getting some benefit from using the high definition codec. And I think that might be a trend we'll see in the future, that there will be more focus on the streaming companies. And I've had some discussions with the streaming companies, and I think they get that. I think they get that, they're the party that decides what codec to use. And on the device side, they're just trying to be compatible with everything, right? And no one's paying more for a TV, because of the codec. They sort of want you to have every ability possible to play any content, but you're not really choosing what that is. So I think that's interesting. And, I find on the cellular side, bilateral licensing is still the model that's most favored by licensees and licensors. And there hasn't been a pool that's really been able to solve the, all of those interests and put that together. So, there I've found it's more bilateral licensing.
Interesting. Yeah, I actually had the case recently that I learned from an article that YouTube, if you are, not subscribing, but you allow the commercial, they use a different codec and a low resolution, of course, as if you would subscribe and pay for it, then you get the high HD, of course, and then they use more of the latest codecs there, which is, again, right, the minute you pay for YouTube, you're also using a higher, better, later version of the codec, right? And that makes a lot of sense because you can switch it on and off, right? As you said, I don't buy a new iPhone for subscribing to YouTube, but I can switch on and off the subscription. So that makes a lot of sense to have it on the codec, on the content side or platform side of things, where it actually makes it different, I guess.
Yeah, and I think they have more control over the pricing, right? Because I believe Netflix has an option where you pay more for the HD content, and pretty much every streamer out there is looking at that. Can I differentiate the pricing if I'm going to HD? Which I think in the patent sense, maybe that'll be beneficial in the long run because they could build into that the reward for licensors who develop the codecs. So, it could be fair to everyone.
I read also recently that in 5 years' time, the expectation is that 50% of the video content is not observed by humans, but by machines. So I can imagine that, I don't know, automated camera surveillance systems, vision in autonomously driving cars. There are a lot more also use cases for the codecs on the horizon. Do you see anything there yet in trends and new use cases, or is that only up and coming for the future?
For me, I'm more looking at what's out there currently as a licensor. But I as a former computer scientist and someone that's followed AI, I think it's fascinating the amounts of data that AI is analyzing, and there's a whole host of intellectual property issues that go along with that. And maybe there's some patent issues as well if the AI is decoding the video and analyzing video as well. I've always thought of the AI issues more on the copyright side, but I think you raise a good point. There could be if the AI engines need to look at video, they're going to be using codecs, and maybe they're going to be using codecs in unique ways, because they don't have to look at a video the way you and I do. They can look at the data that's actually encoded. So they might be looking at it even in a deeper sense.
Yeah, I think some of the use cases are these image classification, and the higher the resolution, the better that works, right? If you want to differentiate a pedestrian from a I don't know, roadside, or kind of predict where the pedestrian is going, like looking at the direction of where it walks, the higher the resolution, the better the image classification. So these were the use cases that I read about that may be subject to using the latest codecs because of the high resolution and higher bandwidth needed for that, right?
Yeah,
but going back to the Sun portfolio, what can we expect for the future here? Is Panasonic still developing that portfolio? Do you get more patents there? Are you building it in any direction? Is it growing, or are you commercializing it as it is now, and then there will be a new program set up?
So I don't necessarily have insight into what Panasonic is thinking for the future. I think they're very happy with the arrangement. We've been able to license the patents and turn a decent profit, and do it in a way that I think is responsible. And so I think that's generally the case. We have gotten new patents. The mechanism of the trust allows them to assign additional portfolios. I think the most recent portfolio I received was EV charging, and I joined the Via LA EV charging pool with that. So I think they, in all likelihood, look at the calculus of, are these patents that we want to separate from the business, or is there a potential need to keep these for a business unit? Because once they assign the patents to me, they lose the ability to cross-license them and license them with their competitors for business deals. So that's a downside of that. But so I think the focus will always be on the standard essential patents.
Yeah.
And we're been well suited to monetize those. So I think in the future, there's a great potential that there'll be additional patents at the trust.
Interesting. That's good to hear, and we will be following that development further. You said that earlier. Of course, the main goal is always to get a deal done, right? Agreement. And there are, however, cases where that is not working. And I think without the threat of at least enforcing, also you have to at some point enforce. I looked at our data, at least in the US, we found only one case where Sun Patent Trust was a plaintiff against HTC. When do these situations typically occur? I know we are working with lots of SEP holders, and they keep, using terms like holdout, licensees that, basically let you wait forever and never respond really, and don't want to make the effort of getting a deal done. What are your experiences here? I mean, it looks like you have been successful without litigation most of the times, and that was an exception, but give us some insights on that particular case and what you experience in the market.
So I really take it as I'm very actually proud that the trust has been in existence since 2015, and we've only had to resort to litigation once. And we've done some quite big licensing deals, some of them in the hundreds of millions of dollars. And we did that without litigation. One licensee told me that I was the biggest deal they ever did without litigation. So, I really feel that is a testament to the way that we're approaching it, trying to be reasonable. But, I think the idea that there's a willing licensee is sort of a myth. And, no one is really willing to take a license at the beginning of a negotiation. They may have a policy to respect intellectual property, but at the beginning of a negotiation, they're going to view you as a problem. They're going to view you as a tax on their business, a tax on their profits, and you have a lot of work to do. You have to convince a negotiation team that you're giving some value, that you did make a contribution to a standard, and that you have some real intellectual property that covers what you contributed to the standard. And even once you convince a negotiation team, the management of the company and the business units are going to be very slow to accept that they're going to have to pay someone. And, I think willing licensee is a progression, and you have to do a lot of work to keep the willingness there, or create the willingness in the licensee. And I think that's done by being reasonable with your opening offer, reasonable to understand what the issues might be on the other side and why they might feel differently about the valuation than you do. And at the same time, you have to also be careful that you're not discriminating against your existing licensees by treating a future licensee more favorable. So that's very challenging. In terms of getting to litigation with HTC, and I think this is in the complaint, so it's public, they had stopped responding to me. It was like 6 months where I kept sending emails saying, well, what's our next step here? What's our next step? And I got no response at all. So I chose to go to litigation. Currently, I am in discussions with a lot of the Chinese licensees, and that's very challenging. And whether or not that winds up in litigation or not, remains to be seen. The trust is actually set up in a way where I have complete freedom to litigate, and I also have the means to litigate. Right. I have a healthy reserve that I can use. I've only had to use it once, and unfortunately, in the future, I think some of the last remaining licensees that I have in the cellular field may be tougher, and there may be more incidences where I'll have to resort to litigation, but I do try to avoid it.
Right. No, that is good, and congrats to be so successful without it. For those Chinese companies, I mean, I can imagine with the ban in the US, can you even litigate in the US, or where would you have to choose the territory and the venue?
Well, that's a great question, and it's very, tough, right? Because as litigation options, I think there's still a little hesitancy to litigate in China. Right. We've seen FRAND rates by the Chinese courts that are much lower in some circumstances. I think a lot of people have eyes on the current Nokia case versus Oppo. And, I think that's going to be an interesting case because China is making the case that they should be a good forum for intellectual property, that they're protecting intellectual property. And I think the courts have to catch up with the political rhetoric, the desire to be on equal footing with the US and Europe in terms of respecting intellectual property, I think is there. And I see it growing every day. And we see Chinese companies becoming licensors as well. So I think there is a strong desire that China be viewed as an equal forum for IP litigation. The reality, though, is that the courts do give people hesitancy to litigate in China. So often, if you're looking at a Chinese licensee, you will look at the Chinese option because that might be where most of their sales are, but you'll also look at where else they're selling. And, are they selling in Europe? Are they selling in India? And all of those options have to be explored. There's been highly interesting developments in the last couple of years where companies have withdrawn from markets just due to IP issues, or at least that's what they say publicly is, right. We're in face of an injunction, we're going to withdraw from Germany. That, was unheard of when I started. You never heard of someone withdrawing from a market because of SEPs. And, I think that's unfortunate because SEPs are not meant to be punitive. They're meant to facilitate adoption of the standard by having reasonable licensing for everyone that's in the market. And I think that's on both licensors and licensees to find what that right price is. Licensees always view the stack should be very small. The amount of money they should pay for IP is very small. Licensors tend to look at, well, we need a much larger percentage of the stack. And I think the courts usually come out somewhere in the middle. So
you see that as a positive development that also courts set FRAND rates, like in the UK. Are those decisions helpful or also difficult to look at?
I think everything that happens is a data point, right? Everything that happens. And I think the unfortunate thing that happens in licensing negotiations is sometimes people are chasing the latest decision only. And, they overly focus on, one decision. I've had licensees tell me, now we only look at Interdigital versus Lenovo. And, then I'll respond, so you're going to pay past damages back to 2007? And they're like, no, not that part. I like the other, I like the rate, but I don't like the past damage aspect. Yeah. So there's a lot of cherry picking.
I was going to say the cherry picking starts, right?
Yeah. And licensees do it and licensors do it. Licensor is going to tell you about the cases where they think it, establishes the FRAND rate is very high and licensees go very low. So I think you have to be wary of chasing the latest decision. And I think the UK decisions are fascinating, though, because we have 3 judges that took 3 approaches, and there are a lot of litigation issues in there that, where, a party failed to provide sufficient evidence on something. So, where the rate came out might not necessarily be an indicator of what FRAND should be for everyone, but it might indicate mistakes that were made in that licensing program, mistakes that were made in litigating the case, and sometimes the licensee does very well, and sometimes they do poorly on that, and same for the licensor.
So a lot of data points, a lot of learnings from those cases when you read them, right? Those different testimony that are used or not used, and approaches that are followed and not. So I think also a lot of good approaches to at least look at and see how the argument was formulated by the different parties. And of course, also fascinating, as you said, litigation now across the globe. Oppo Nokia in India, I heard that Oppo cannot withdraw from India because it's such a huge market to them, the largest country of the world. But also like Brazil and Colombia, even, where I learned the patent friendly courts have a very efficient way to give you a preliminary injunction, even though, not for everyone those markets are big enough yet, but at least I think they triggered some global settlements, right?
I think Brazil has a very good reputation of enforcing IP rights, and I think a lot of companies are thinking about Brazil as a potential, and it's not an insignificant market. It's a fairly large market, so it's certainly interesting, and the globalness, the global nature of licensing is another thing that makes it so unpredictable and so complex, and it really makes someone like me that has to license and say, what is FRAND? It's something that is really hard, and the best answer that I've been able to come up with by looking at all these courts and how IP is treated differently throughout the world and dealing with licensees that have global businesses is you have to have a range for your FRAND. It can't be a number, a singular number. And one of the challenges that we face, so one thing, we can always calculate what we think the total stack is and do some type of top-down approach, and companies like IPlytics are essential for that, to get data on patents, and I think that's something that I like what Judge Burst did with that in Unwired Planet. He used it as a sanity check, and I think that is right. But the other aspect that's hard in a licensing negotiation, and if you get to litigation, it becomes part of the data. But in a licensing discussion, I can't necessarily reveal my other licenses due to confidentiality.
Sure.
The transparency is awful in patent licensing, and the licensee can't tell me their deals, right? But what's the court look at mostly, or as one of the important factors when they're doing the calculation of what's FRAND? They look at the licensee's deals and the licensor's deals, and will consider whether the licensor has a consistent policy, etc. So when I'm in a discussion, I tell licensees I've been fairly consistent, and I can give you an idea of where my deals have wound up. I try to be as transparent as I can, given the confidentiality obligations. But that's very tough. And, I wonder if that regime of confidentiality that people voluntarily choose in the bilateral licenses, I don't recall the last license I did with no confidentiality, if any. I'm not sure if I've ever done one. But, people choose to make all this confidential. And that's what they struggle with most when they get to a negotiation, is it's all confidential. Yeah. And then, when you go to a court, it's not confidential to the judge. And the judge looks at all this, and he's so much better suited in some ways to make a decision. So I think licensors and licensees should work on their transparency. They should work at ways to share information that doesn't violate confidentiality. And I think it requires a lot of honesty. And a lot less bluffing that goes on in these negotiations, because
I can see that. I mean, maybe like a third party, neutral party outside, of both organizations that gets the clear data. They can calculate averages and then come back with that average number that is then, outside of the confidentiality agreements, because it's aggregated and it's, detached from specific contracts. We work with some economic consultancies who have that in court, and they do that, even though that still is, of course, not every contract is written the same. There's site conditions, and it's not always comparable. But there's some fascinating work I've seen on aggregating information on that. So if that would be more systematically available, I think we could, we would have a much better situation of getting agreement. I'm sure. But this,
and on that, when you do it in court, right, it's going to cost you $10 million to get that answer. I've made the offer to many licensees. Why don't we take my agreements and your agreements and give them to an independent party under confidentiality, and have them come back with a recommendation on what the licensing can be, and it could be binding or non-binding.
Sure.
But let's have someone look at that, so that we're not just guessing as to what each other have done in licensing, and we get some real recommendations.
Yeah, well, that's an interesting thought. Great. This has been really exciting, Joe. Time flies, and we're getting to the end of the podcast. But my final question is always, with anyone here on my SEP couch, what do you want our audience and our listeners to remember? Any final statements that you have?
So you earlier asked me about the latest decisions and how they affect licensing. I read the last two decisions in the UK in a different light. I'm not looking at the numbers that the judges came to, but things that the judges said that to me should be taken to heart by licensors and licensees. So in the Lenovo case, Judge Melnor talked about how complex the evidence was. And he said he did 4 days of pre-reading before the trial. The trial was 17 days. And he said that was woefully inadequate, and that he got 50 bundles of materials and pre-hearing briefs of 400 pages each. And that, it was basically impossible for a judge to figure this out. And what he said, and I'll quote him, "I observe that this sort of FRAND case is not well suited to adversarial litigation." That's a judge saying that. Right. Because there is, and was in this case, very little, if any, exploration of the middle ground between the positions taken by the two sides. To me, that's the judge telling us that we need to work harder to try to solve these things, and that we're much better doing it outside of litigation. And this was echoed by Judge Smith in the Apple Optus case. First of all, he said, practically speaking, it's impossible to figure out how many SEPs there are. And practically speaking, it's impossible to figure out whether they're valid. And then he had a quote that's very similar to what Judge Molnar said. It's relatively rare for courts to involve themselves in what is, after all, a matter that should be for the commercial agreement between the parties. And he says, save, in certain contexts, courts don't involve themselves in setting commercial terms or terms that are FRAND because they are unsuited to do so. Right. And, that's very interesting, given he must have written about 200 pages to try to come to the answer. But he's saying, look, I'm not sure we're the right place to be doing this. And it's really on the parties to figure this out. And I'm a firm believer in that. And, I'm trying with all my licensees to get to the right numbers in terms of where they fall in the FRAND range. And it's tough. And I think we all should try as licensing professionals and, to really get to the better answers and avoid the conflicts. And I think the data that your company provides is so great because data doesn't lie. It has to be interpreted, but data is data. And that has helped many negotiations for me.
Great to hear that. Thank you so much for so much insight and some very interesting quotes you left us here with to think about. A lot of good information. Thanks for joining the SEP Couch Show. Thanks for your wisdom and experience. I hope to see you soon. Listeners, thanks for listening in, and I hope to hear you also in the next episode. Goodbye.
Thank you.